Thank you. My name is Marshall Burke, and I am the Dean of Tulane Law School and the Mitchell Franklin Professor of Law, and it is my great privilege to welcome you to the William Tetley Lecture in Maritime Law. The Tetley Lecture honors a towering figure in maritime law with special ties to Tulane. Professor William Tetley led not one, but 3 distinguished careers. A graduate of McGill University and the Laval Faculty of Law, Professor Tetley built an acclaimed career first as a practicing lawyer. He practiced for nearly 20 years with one of Canada's premier law firms, having obtained the rank of Queen's Counsel in 1968. Professor Tetley then transitioned into a high-profile career in government service, ultimately as a member of the Quebec National Assembly and a cabinet minister. It was only at that point, a quarter century into his professional journey, that he launched his career as an academic, joining the law faculty at McGill in Montreal. And over the next 3 decades, Professor Tetley established himself as one of the world's leading experts in maritime law. For 15 years, from 1984 to 1996, Tulane Law School was fortunate to count Professor Tetley as one of our own. During that period, he served as a distinguished visiting professor, traveling annually to New Orleans, as he put it, going south each winter like a Canada goose, to teach a course here at the law school, where he was beloved by students and colleagues alike. In 2001, the law school created this lecture series in Professor Tetley's honor. Somewhat unusually, and this is definitely before my time, because I would have thought twice about this, this lecture series was created without an endowment to support it, but simply in tribute to a colleague who had greatly enriched our community, our students, and the entire field of maritime law. 10 years later, in 2011, upon learning this, Professor Tetley himself made a generous gift to endow this lecture series into perpetuity. Tulane's tribute to an eminent scholar and dear friend was thus returned, demonstrating again just how special a friend he was. Through the years, the Tetley Lecture has attracted leading figures in the maritime field from all around the world, in academia, industry, government, and legal practice. And tonight is no different. To introduce our distinguished speaker, I will now turn the podium over to our own Martin Davies, the Neil F. Johnson Chair in Maritime Law and the Director of our Maritime Law Center. Professor Davies.
Thank you, Dean. As it says in the leaflet that you have in front of you, Bill was a very proud Canadian. That is the Order of Canada pin that he has on his lapel there. And Bill died on Canada Day. But my task is not to talk about Bill, it's to talk about Rob Merkin. We're very, very pleased that Professor Merkin could join us this evening. You have a very truncated biography of him in your in the sort of piece of paper you've been giving women in the leaflet. Rob presently works at the University of Reading, but has previously been at University of Exeter, Southampton University, and has had visiting positions, well, as you can see, in many countries around the world, particularly in Australia and New Zealand. And so he has a special connection with a law firm in New Zealand and has done, or did quite a lot of work about the insurance ramifications of the terrible earthquake that occurred in Christchurch, New Zealand. Now, he was saying last night that he's not really a maritime lawyer, but yes, he is. But he has a special interest in marine insurance, which is what he's going to talk about tonight. As you can see here, he has he's the honorary vice president of the International Association of Insurance Law. I'll just let you have a few moments to sort of take that in. I mean, that's quite a big deal in the insurance law world. He has been the president of the British Insurance Law Association. So, although there is this obvious special expertise about insurance law, he is indeed actually a nut. And so, without further ado, I'm going to load up his slides here. And I invite you to join with me in welcoming Robert Merkin.
Thank you very much, Dean and Dean Martin. Thank you both for that lovely introduction. It's a great honour to be this epic. Do you anyone mind if I strip for actions?
You only kept it on for like
socks when I wear a jacket. Thank you for the invitation. It's a great honour to give this lecture. And I had two great research assistants, so thank you both for your help with that. And okay, here we go. Slightly controversial topic is argument of faith and benefits. And the reason it's controversial is that if you ask any contract lawyer, what's the distinguishing feature of insurance law? They'll give you various answers. Or you have this single insurable interest. You have these bizarre things called warranties that automatically bring an end to the risk if you break them. You have the indemnity principle. But key, you have the principle of utmost good faith. And it's a mantra that you can see from my first slide has been knocking around since 1707, as long as me. So you can see that it's a concept of long-standing, but it's only fairly recently we don't understand what it actually means. And I'm still confused, but hopefully you won't be after I finish this. The breaking into Latin, Verum Fide, is first mentioned by a council, in this case of Cool and Cochrane. It's not very well reported. In those days, the reports were by court reporters, and it was said in one court report, called Espinez, he used to listen to half the case and report the other half. So it's not always accurate to get what was actually decided. But the words of Verum Fide were uttered in 1707. But the case that everyone knows and loves is in 1766, Time from Bow, where the concept of good faith was articulated. No, there's no utmost there, it was good faith. Utmost, as you can see from my slide, was a 19th century add-on. And there are a number of different formulations that you find. Absolute good faith is, and there were several others, but utmost was one that stuck. And as we'll see, that was the one that was codified. But what did it mean in 1766? First thing to note is that Lord Mansfield was a Scottish lawyer, therefore trained in the civil law tradition. So he was getting his learning from other sources other than law. And this was a case involving Ford Sumatra. And about 92 years ago, a group of Australian lawyers gave a pilgrimage to bow and wave the place. He's still there, just now. But it was basically a trading post in those days. And what he did was to ensure his own trading efforts, bizarrely using a marine insurance policy to do so, because that's the only woman that was knocking around in those days. So he ensures his trading interests, not disclosing to the underwriters in London. He sent his brother on a ship across to London to take a place policy. Didn't tell them that there were French fleets hanging around. Now, this is in the midst of the war, as the to the Indian War. We call it French Indian War, but in fact it's a 7-year war, because it actually fought from 4 different continents. And what was going on here was, I hate to say to this audience, just a sideshow. The real action was in India and on the European continent. That's where it was really fought. It wasn't fought in Australia, because at that time Australia didn't exist. Australia only came to existence after you guys came independence. We had no others in their comics. So that's the war in Australia, but everywhere else in the world, England started France, and it had been for about 800 years. We only stopped doing it in 1815, officially. So we hadn't told the underwriters. We had there was infantry around. He hadn't told the underwriters the defences before, even though it was good fought, it was not really defended at all. It was just playing first. So it's taken, insurers decide, or underwriters decide to avoid the policy, refuse to pay, and Mansell lays out his classic statement, I'm sure Martin and also recite in their sleep, about good faith contracts made on speculation. So I haven't set it out here. There is a paper for this, and Faulkner is very kind to me. We published in Tulane, but he was concerning pretty complex. So he made the point that it was mutual. It rests on fraud, but you need to use the word fraud carefully. It means constructive fraud. When you're withholding information. And there is a view on one reading of this, of Mansell's judgment, that he was referring to all contracts and not just insurance. That has not been perpetuated. We'll see it's been confined to insurance. Bizarrely, as is often the case with leading cases, the result wasn't the one you expect. The insurers actually lost, because everybody knew in London that the French were trying to grab everything they possibly could in that part of the world. So there was actually the rule that is laid down, this regards now the exception, but it was actually the original rule, was that if the insurers know what's going on, you haven't got to tell them. So the exception creates the rule. And thereafter, utmost good faith, or sorry, good faith, begins to permeate the cases. But at this stage, it's really confined pre-contractually disclosed by the policyholder. Oh, one other quirk of capital law. Because of the communication period between the policyholder deciding he wants to place the risk and sending his brother to London, by the time the policy would become placed, the fault would be taken 3 months early. It's actually vagaries of insurance or communication at the time. And indeed, one of the issues of the way that insurance was developed was partly because of that communication. That we didn't get telegraph until the 1860s. And I think our piece, the message to your president, which took about a day to get through in 5 words. But that was really the start of communications. So Atlas begins to appear in about the 1840s or 1850s. It's confined to pre-contractual disclosure by the policyholder. It's an important point. And as I said on the slide, up to 1906, there are no cases applying good faith in any other context. There is a suggestion in 1797, in the case of Walter Horncastle by Mrs. Buller, who was the disciple of Lord Mansfield, that insurers who pleaded technical defences were not acting in honest faith. But that point was never taken any further. And there was a case in the 1860s involving a fraudulent claim by a policyholder, and the judge says, utmost of favour requires you not to make fraudulent claims. But again, the case turned on express wording of the policy didn't arise. So when we get to the crucial year of 1906, the only real authority we have on our utmost of faith is pre-contractual disclosure by the policyholder. Now, in 1906, So Mackenzie Chalmers, who had nothing better to do, had spent 12 years trying to codify marine insurance law. He'd read, he claimed 3,000 cases, although, my view, he was read about 2,000 of those. Nevertheless, he codified the marine insurance law into the marine insurance of 1906. He'd actually codified goods exchange, partnership. This was his thing. He was a judge during the day and a codifier at night. Those were the days. Section 17 is in a group of 4 sections. It starts off by saying, Section 17 says, contract of adherence, contract of utmost of faith, and good faith not be observed by either party. The policy is voidable. Set it aside and defer, as we wouldn't do for this representation. Section 18 sets out the rules on disclosure. Section 19 sets out the rules on disclosure by brokers. And Section 20 sets out the rules of misrepresentation. But you'll see that the group sections, 17, 18, 19, and 20, are all concerned with pre-contractual presentation of risk by the parties. There is no other context in which utmost of faith appears in the Act. And the sole remedy is avoidance. This is the same in this jurisdiction. You pick up in Carter regulars here, and the position is the same. I won't try to mention Wilbur boats and Circuit going off on a tangent of its own, and decided that it's not recognised federally, and therefore we won't accept it. But I'm in a building that I think that occasionally sits inside. Maybe you shouldn't say too much, particularly unusual. Now, if you think about this, there are 4 possibilities for this sort of things. Pre-contractual disclosure by the policyholder, pre-contractual disclosure by the insurer, post-contractual duty policyholder, post-contractual duty of the insurer. And because Section 17 is not the way it is, and the contract with marine insurance is a contract utmost of faith, that could apply to all 4 possibilities. But the remedy is avoidance. And the point that I've been trying to make, hopefully, is that when you come to codification, and this was meant to be a codification, it wasn't meant to change the law in any way, it was codification. When you come to that, there is no authority anywhere which gives you utmost of faith in any other context other than in policyholders pre-contractual disclosure. So it makes sense. Policyholder doesn't disclose material facts, the insurer can walk away. But because Section 17 isn't drafted in that way, you then look, well, how can it apply to the other context? Insurers pre-contractual duty, the insurers owe a duty of disclosure as a policy. Well, if you read the mandatory judgment, there's a couple of lines in there that suggests that the insurer does. And Mansfield uses the example of the arrived ship. Intelligence was much more widely obtained by underwriters than it was by policy. So you might get a situation where the policyholder goes into the insurer and says, I want to do anything like here. And the insurer doesn't know that it's all right, same. So there's nothing to insure. But they get the premium anyway. Now that would be a classic example where Section 17 would work bilaterally. And the remedy fits because it's avoidance of the contract that you wouldn't otherwise have entered into. But when you then try to apply the Section 17 remedy to post-contractual uses, you run into problems. Let's suppose the insurer has a post-contractual duty of some sort. You know, it is what comes to that, but let's suppose it is. What's the remedy? Avoidance. And anyone who's been through Martin's contract says, well, no, you don't avoid the post-contractual breach. You avoid the pre-contractual misrepresentation. It's breach of contract. And that gives you different remedies, like if you're right to terminate, as what there is a breach, but it does give you the right to avoid. So the remedy does not fit the crime, basically. And if you apply that to the insurer's post-contractual duty, you get the same result. Let's suppose insurers are duty of some sort of post-contractual and claim within a reasonable time. Section 17. As a policyholder, I can avoid the policy. That would teach you. It's just useless, it's just irrelevant to the problem. So Section 17 is not helpful. And the common law codification is therefore based upon the notion that utmost of fairness is defined to pre-contractual disclosure by the insurer with a possibility in some remote cases, which have disappeared actually because now we have communication, which we didn't have in 1766, that the insurers might owe you disclose what they know part of about risk. Okay. Then we get statutory reform, and I've gone to a number of jurisdictions to talk about this because there's been a lot of action fairly recently, you can see. This jurisdiction I can deal with in one sentence, nothing. There's no further limitation on this. In the UK, in 2005, we set up, the Law Commission set up an inquiry into the reform of insurance law. The idea was to do a mass codification. The Law Commissioner at the time was a codifier. He believed in codes. He was disabused after that. You can't do it. You can deal with certain bits, but you can't do the whole thing. And we then went through a 10-year process. And I was consulted. I was fortunate enough to be sent to Australia and New Zealand to see how they did it. And I produced a paper with reverse transportation, which the Australians got, and no one else did. But what we have in the UK now is the consumer duty, which basically is abolished duty disclosure for thing. But for businesses, we have a duty of fair presentation of the risk. So non-disclosure is threat and no loss of the bill. It's fair presentation. What do we do about utmost of faith? We amend Section 17 and delete the remedy. So we now have a statement. A contract with insurance is a contract with the utmost of faith, full stop. How's that for a pregnant full stop? In New Zealand, I should say that the Marine Insurance Act, because it was a British statute, was adopted by something like 8 different countries, including Canada much more recently. And everyone codified it pretty much the same way. Australia, for some reason, was the last 6 sections first. So if you know what the law is in Australia, you have to add 6 to everything that you say in England. And they also made it he or she, which no one else has done. But in New Zealand, much more significantly, there was no Section 17. Now, I've tried to find out why, and nobody knows. It could just be a mistake in transcription. Who knows? It could be deliberate, but why would you make it deliberate? I have no idea. Anyway, there is no Section 17. But the New Zealand courts did begin to manufacture an utmost of faith principle in the context of the earthquakes. And it was mainly to do with claims handling by insurers who were doing some very strange things. I ought to explain that, again, this is really off the topic for you there anyway. In New Zealand at the time, there was what we call the Earthquake Commission, which picked up the first 100,000 million dollars, 100,000 New Zealand dollars, which is about $2 million to US dollar. They now increased that to 350,000, but at the time it was 100,000. But if you got a claim of 200,000, but 100,000 from the state and 100,000 from your private insurers, who had different legal advisors. Now, my youngest daughter is a solicitor in New Zealand, and as soon as she qualified, she was thrown straight into this with the AI, which is a firm I'm sure you know well. And the biggest problem she had acting for private insurers, trying to get any sense out of the earthquake commission. So the claims were always late because the two sets of lawyers couldn't agree as to how much damage was, whether it was about 100,000 and whether the private insurance called in, and so on. So you can imagine the delays that were caused. The delays reached such an extent that in 2020, this is 10 years after the earthquakes, New Zealand had a special tribunal to deal with funds. And they're just about work their way through now, but it's a long process. So our muscle effect begins to feature in some of the New Zealand cases, but it's because attributed to pay on time. New Zealand last year codified its insurance law. And again, I'm lucky enough to be consultant, so I was fit New Zealand to see my daughter. But they didn't know what to do with it, because they said, we need to have to make an legislation now. And the insurance industry went absolutely berserk today. Put that in, it's fair, even you get all these bizarre cases like that. You can't open this Pandora's box. So they did, they put it in there, and it basically said, common law applies to almost all facts. Whatever that is. So we have an uncertain state. Australia, by contrast, 1984 went a step further and made utmost effect a contractually implied term. So if you don't observe good faith, either party, you are in breach of contract and therefore liable in damages. And as we'll see a bit later, Australia's expanded that sort of regulation measure as well. So we have utmost effect now all over the place. And perhaps I should just add that in Australia, they have the Marine Insurance Act as well as the Insurance Contract, 1984, and the Contract Act was not applied to marine insurance. Marine insurance is separately regulated by the old 1906 section added on at the beginning. But pleasure craft have been taken out of the 1909 Act in Australia and put into the Insurance Contract Act. You've got a consumer-friendly act for non-marine and pleasure craft, and marine insurance and everything else. So they still have the concept of utmost faith as an implied term for non-marine and as something else that no one quite sure for marine. So, what is utmost faith? First question, what does utmost add to the good faith? Why do we say utmost? And I have no idea. You will find learned articles in journals, actually from this jurisdiction, discussing whether utmost faith is different from good faith. And like all the things, you come to those serious conclusions. But the then gets to the real key question: is utmost good faith a duty to avoid being acting in bad faith, or does utmost good faith mean something else? There's at least one English statute says that you're only in breach of the duty of utmost faith if you're acting in bad faith, fraudulent or reckless or dishonest, whatever. But the Australian courts sees you out. This is the key case, I think, the root case on meaning of utmost faith in insurance. So it's based on their legislation. Makes it clear that you've got good faith and bad faith, and you've got a whole range of possibilities in between. And all of those things constitute utmost good faith. So it's not simply nasty, vindictive or fraudulent conduct by the insurers. It's failure to act with the utmost good faith. So we know it's a wide concept. And we've also had a recent Scottish case called Cowley and Vitality, and it may be your health. If you want to retain your sanity, you don't know read a Scottish case. We got rid of that in the English courts in 1992, 1993, I think. The Scots love it. They don't have plaintiffs or claims, they have pursuers and defenders. And they have, if I go to Scottish case, I do need a dictionary. I need to go online and see what they're actually talking about. But Cowie is a case which basically follows the CGU and AMP line. saying that utmost good faith is not simply bad faith. It is anything that is not good faith. So you've got this whole range of possibilities. So it's a wide concept. How does it interact with contractual rights? If you have a contractual right as an insurer, can utmost good faith stop you relying upon your contractual rights? And again, going back to New Zealand, recent case with Pierce against the Natural Hazards Commission. The Natural Hazards Commission is effectively titled as the earthquake last year. And basically, the Natural Hazards Commission tried to rely on the limitation period. And you can imagine that if you've got earthquakes in 2010, everyone's negotiating like bond like mad. 6 years that you've got to make claims, then suddenly disappear. Can the Earthquake Commission rely on this limitation? Policy holder says, no, it's not fair, it's breach of your utmost good faith. Court says, no, utmost good faith does not stop you relying on the rights you would otherwise have. So we're beginning to see the parameters. It means more than that being bad faith, but it doesn't stop you relying on your contract. So what are we doing about it? And there's another development that I need to refer to, which is the exercise of capital discretions. I don't know if there is a similar concept here, but there's an English Supreme Court decision called Braganza in BP in 2015, and that concerns contractual discretions. And the Supreme Court basically said that there's a duty not to exercise a contractual discretion irrationally. And those of you who are involved in public law know there's a distinction between rationality and reasonableness. Reasonableness means that you second guess. Did you act reasonably? No, we wouldn't have done that, but therefore you didn't act reasonably. Did you act rationally? It's a different question. It is, did you take into account the right considerations? Did you hear the plaintiff make their case? It's an administrative law test. But how does that relate to utmost good faith? If there's a general contractual obligation not to act irrationally, how does that relate to utmost good faith? And in fact, in my view, there's very little to choose between the two. But let me move on to use some more examples. The remedy to breach using utmost good faith. We know in Australia it's things like that. And it gives rights to damages. And that's been the case since 1st January 1986. So where are we now? 40 years old? How many cases have damages been awarded in Australia? 1. And that was for a late payment, and that was a case that I think is a fairly low court, never been repeated. So the principle is there. You've got remedies for utmost good faith, but never used. There's also a provision in the Australian Act which says that you can't unreasonably rely on policy terms, but I'll come to that again a bit later. So what do the Australians do? You've got this implied term that no one's using. So they decided to make it administrative, and they called in the regulator, the ASIC, which is the Securities and Investment Commission. Australian. And that allows ASIC to bring representative proceedings in the names of policyholders if they get sufficient number of complaints. So you've actually got a regulatory remedy because no one is relying on contractual. And it gets worse than that, because if it's a regulatory remedy, breach of regulatory rules means if you're naughty, you lose your license. So in theory, an insurer could be stripped of its right to carry on business if it doesn't act in good faith with its policyholders. That's why you can see the definition of utmost good faith is so important in the Australian jurisdiction. It's never happened. But it could, and I suppose that keeps the insurers on the straight and narrow, spreading all of this. Probably worse. In the UK and in New Zealand, all we have is dispute, as I said, is equivalent full stop. Contract of insurance is contract of arms of faith. So what? There are three possible, it's not an implied term, so there are no question of damages claims, but there are three possible remedies that you can look at. One of them, and this is what the English Law Commission said, was it's interpretive. That you construe policy terms perhaps more liberally than you would do ordinary contractors in favour of the policy. If that's right, not a big deal, because we have consumer rights that does that anyway for all contracts. Secondly, it could be the basis for implying terms into a contract. So it's not an implied term in its own right. You can say, well, it's easier to imply a term into a contract than it would be. The rules for implying terms into a contract are, certainly in the UK, I'm not sure what it is here, very rigid. They used to use the example of the man on the patent omnibus, which, for reasons I was about to explain, is a very odd statement because the patent omnibus is single decker. But nevertheless, that's the test. It's very hard to get anything like that. But it could be arguably easier in an insurance case. And the other possibility is insolvent. Going back to what Justice Buller said in 1797, an insurer shouldn't be behaving like this, relying on technical defence, taking premiums notes, knowing he's not going to have to pay, and it therefore could be stopped relying on his rights. But our friends in Scotland and Caroline Vitality have settled that, so no. So we have a beautiful concept of utmost of faith with no remedy. And I remember being a law student being told, it'll be used if you're reading. If you haven't got a remedy, you haven't got a right. And in New Zealand, the common law reached a position that you use utmost of faith as a way of implying specific terms, like not paying late and so on. And that's what the codification in New Zealand has effectively meant. So, just looking briefly at the things that the ways that utmost of faith might work. Insurers proving fact producers. We know about the insurers proving fact producers. They are now fair presentation. Take it. Utmost of faith is divorced from presentation, result, policy, or whatever. They're all separate. So we're talking about what duties may an insurer owe pre-contractually. And I have no doubt that the ride shipping example that Lord Mansfield made in Carter and Burns still holds good, although it's never actually applied. But it certainly holds good. It's been suggested that the insurers owe a duty when the insurer makes its presentation to make sure that everything that needs to be disclosed has to be disclosed. The idea is that the presentation of the risks by the policyholder is bilateral process. Insurers have to engage in it, not to just sit back and say, okay, you disclose, and I'll wait to see what happens. There is a case called Bank Case Woman, Scandia in 1987, and this is a case that I actually worked on when I was working for Reed Smith, the words I reached out with those Reed Smith. And this is a case where there are several parties involved, and there is not one single honest one amongst them. They made a film of this case, you can say that. It was a gentleman who wished to borrow money from the bank, and he provides two forms of security: a bag of valuable gems, which are valued by an independent valuer, and he also provides a security in the form of an insurance policy. Now, it turns out that the valuer was a crook in the pocket of the borrower, but the insurance broker placed the risk as a crook. He didn't place the crook out he should have done, but the insurer who accepted the risk was also a crook. and knew that the broker hadn't placed a line on the trades. And the idea was that the insurers would give duty to the policyholder through their employee to disclose what they knew about the whole transaction. That failed on the grounds that the only remedy you would have is avoidance, which didn't, this is the last thing you want. And there was also a policy exclusion for fraud, so that didn't work either. The solicitor who was working on this case confided in me that he wouldn't have been the least bit surprised if all these 4 people were living on an island together. But that's all we got. But the point is that we actually wrote this. And thanks to my research assistants here, there are 2 cases, commercial unit and flagship, and lawyers and inland fisheries. In both those, there are statements that insurers owe free contractual duties. But they don't amplify those statements, don't say what they might apply to this there. And finally, yeah, that there is soft law provision for disclosure that in Australia and New Zealand there are various codes, and in England there are various codes of practice, codes of conduct for insurers, which are enforceable. So insurers got that fair towards their policyholders, and Australia there's a whole raft of things that insurers have to disclose. They have standard terms, and then if you're going to deviate from the standard terms, you've got to tell the policyholder. So, how does it affect in relation to insurance for contractual duties? Not really. The assurance post-contractual duty. There are certainly situations where a policyholder owes duties post-contract to disclose. And I'll give you 3 examples. Open codes, declaratory policy, reinsurance contracts, where they have a framework contract ending with declaration. So a typical maritime open cover, policyholders should own 10 our policy, and you can exchange small cargoes to the policy as you go. The premiums are raised up front, and there are some forms of declaration policy which are known as non-obligatory, where you simply have a framework whereby you can funnel proposals through to insurers, and they can decide whether or not to take the particular risk. So you've actually got 2 contracts. You've got the framework contract, and you've got the individual declarations. Now, as long as the framework contract is non-obligatory, so insurers are not obliged to take the risk, there's definitely a duty of utmost effect or presentation of risk. But that's one situation where they would get a post-contract review. Change of circumstances before issue of policy. Interestingly, the US and the UK vary on this. The American view is that if you've agreed the contract and the risk is to incept in a week's time, for example, and something happens in that intervening period, you've got to disclose it. The UK view, and the wording of the legislation is quite clear, is that once the contract is made, the duty comes to an end. So there's a slight variation between the 2. And of course, expressions. You can have an express term which says, if anything happens, you've got to tell us. And if you don't tell us, we can terminate the policy. Those clauses are construed very narrowly in England. And they mean, unless you tell us that the risk has been fundamentally changed as opposed to gently increased, then the clause don't apply. But of course, if the risk fundamentally changes, policy is discharged anyway. So those clauses have in fact been written out in English law. There are, leaving aside the disclosure stuff, situations where there have been cases where policyholders have been accused of not exercising good faith. Camellia and West Islands is an Australian case, and it's a house that is damaged by a fire, I think. And the policyholder puts in a claim entitled to indemnity for rebuilding. But he also goes along to the local authority and says, please can you impose your higher rebuilding standards on this house. So it's actually going to cost the insurers more to rebuild, which they do. Insurers say this in bad faith. Of course, there's no retirement to it. Equitas and MLI is a reinsurance case which actually was settled annoyingly. I wanted to know what the answer was. But basically what happened was that mesothelioma, the way that insurance worked in England on mesothelioma was that any exposure gave rise to liability. So any insurer on risk at the time of any exposure pays 100% claim. So what you've actually got is a whole load of insurers insuring different people on risk at different times. And this all feeds through to reinsurance. And the question that arises in this case is, can an insurer spike its claims? In other words, can it bring all of its claims which it has to deal with on different years into 1 year, so it can aggregate them and claim against the reinsurers? And the Court of Appeal thought that there was good argument based upon an implied term that that was the case. And then it went to the Supremes, and the parties damned them settled it, so we'll never know the answer. But there is an argument, but I think it's a very weak one. If you've got two policies having the same loss, it could be bad faith to apply claim against one insurer rather than the other. But of course, the answer to that is the other insurer's got contribution claim. So I don't think there's anything in that. Diamond World Pattern is an Australian case which I had to read several times to actually believe. A break-in at a jewellery shop. The thieves are a bunch of Crusoe clones, complete idiots. They leave bloodstains all over the place and suck in glass and drop most of the jewellery outside the shop, and then it gets away. So that obviously sort of keeps the cops, I think. But the broker comes in, is something like the issue. Then comes the broker, and the broker says, the best thing you can do is melt down everything that has been sold. Put it in a claim against the insurers, and then so when the insurers come in, everything's been rebuilt, but it's going to be rearound. And then he goes to claim. How are we supposed to work out what we've lost in those circumstances? The answer is the insured recovers what it can prove that it's lost. But there's another side to this case which I'm going to in a second. So, utmost of favour, factor. Diamond World Pattern is conceded the insurers not acted with utmost of favour. But what's the remedy? You only get what you can prove. But what will be the remedy without utmost of favour? Get what you can prove. Doesn't make any difference. And then we come to the insurance remedy. And I have to mention very briefly what happened in the Diamond World case, because the jeweller in this case was a bit chaotic, didn't keep any records, didn't have CCTV, and the insurers knew that. So when they asked him to prove what losses happened, they said, please can we see your records? And he said, well, I haven't got any. You knew I haven't got any, but they insisted on seeing the records. That was obviously bad faith by the insurance. Did it make any difference? No. Because you can't do what you can't prove. So once again, bilateral bad faith makes no difference in this situation. Does utmost of faith operate only on express terms and established laws? The answer is yes. Allianz and Delview, an Australian decision in 2022, basically it's a high court. High court, by the way, is the Australian Supreme Court. They work backwards in Australia because they're upside down. Supreme Court is the lowest tier, and then you go up to the High Court to the top, which makes sense. But they basically said that it doesn't add anything. It simply builds on what's already there. But then you've got Braganza, and how you add, Braganza principle is you've got discretion. You can't exercise it out there, so what is actually adding to what's already there? The Allianz decision has been very heavily criticised by a judge called Mr. Justice Jackman, And for those of you who are wondering, yes, he is Hugh Jackman's elder brother, Ian Jackman. So a bit of Wolverine. Because it's a criticism of the Supreme Court. In my paper, I've actually even referenced to Ian Jackman's critique, but he's basically saying, you was whack this. You've taken any possible meaning away from it by saying that it had nothing to establish laws in this sort of sense. And I've already referred to Peterson Taku, natural hazards, so my narrative is good. Peter's case says, if you've got a fact right, yes. Duties on exercising legal rights and sort of drawing to a close. Drake and Crawford was an interesting case in England. I won't give you the precise facts of that case, because it was a complex motor case. So let me just give you an example of what they're talking about. Let's suppose you are charged with a criminal offence, and insurers ask you the question on the proposal form, are there any outstanding charges against you? And you think, well, I don't know, and you don't. You take out a policy, you suffer a loss, make a claim, insurance then discover that there was an outstanding charge against you, by which time you've been acquitted. Right, so you're disclosing something that was irrelevant. It was material at the time, but it's not relevant to the actual claim. And very prominent with the view that in those circumstances, the insurers wouldn't have the right to rely on that or non-disclosure. Their own duty of good faith would stop them acting in bad faith in those circumstances. But then our friends in Scotland say no. Under the new legislation, there is no scope for any additional duty in relation to fair presentation of the risk. So it's very improvident, although it's a Court of Appeal case in England, and the court in Scotland is a first scale. Maybe I should explain that in Scotland, one of the many bizarre things about this system, the lower courts will be out of house, the Court of Appeals will be in the house. Well, but they basically said that it doesn't survive the 2015 legislation. And finally, policy restrictions. Eaglestar and Cresswell is a reinsurance case that I don't know, it's inside out and backwards. But it's a case in which reinsurers have a discretion whether or not to pay defence costs. And that discretion said by the court, you have to exercise that discretion rationally and not by any sort of collateral reason, like putting pressure on the policyholder for some other contract that you're negotiating, or because you don't like some other reason that has nothing to do with the contract itself, which of course is what Briganza says. So what starts off as a general, a specific insurance group, is now incorporated into Briganza, and Eaglestar and Cresswell decisively for that proposition. And finally, I think this is my final slide. It is. No, it isn't. Making a protest is a recent English decision. And it refers to an Australian case, which I won't bore you with, where there's a whole list of propositions about policy restriction. And making a protest basically got to the Australian approach. So it gives every discretion, there's a limit on the insurer's discretion when it comes to how they can act, exercising that discretion. But again, if you read it, what does it have to depend on? Absolutely nothing. And finally, I think this is my last slide. Well, it's in cases. The interpretive of those with faith. Our insurance policies being construed differently from other contracts. The FCA and Arch case, Sanitary Product Authority and Arch, lays down how you construe insurance contracts. And you may be interested to know that in FCA and Arch, the Supreme Court overruled the decision based upon Hurricane Katrina in this jurisdiction. Of the because we had a business interruption case, one of the hotels, the arbitrator and upheld by the judge said that because the city was closed down, the damage done to the hotel by the fire hadn't caused it any loss, because it had suffered the same loss anyway. So there was no recovery. And that was reversed in FCA and Arch in the context of COVID. And needless to say, the arbitrator and judge who decided the New Orleans case were actually two members of the Supreme Court. And in a very gentlemanly fashion said, oops, we got it wrong. So one of the big hotels in New Orleans that should have recovered, but didn't, can now say we should recover. But nothing you can do about it, it's limitation period been gone. But there is a suggestion in FCA and Arch that maybe insurance policies to be construed slightly more generously than other contracts in favour of policy order. The difficulty with that, and sorry to break into Latin this time, is the contraproperensum rule. The problem with the contraproperensum rule is that you construe a term against the person who drafted it. But who drafts insurance policies? 9 times out of the time, it's brokers who are acting for policy. So how you apply contraproperensum in that situation is anyone's guess. The English view is it cancels itself out. The Australian view doesn't matter because the insurers are still properly terms. An interesting concept. The two final points. There is this principle in Australian legislation I mentioned that Australian law allows or prevents insurers from relying on contract terms unfairly. And there's one case with Australia voting against Ellis where they did that. This was a motor case, as the name might suggest, against modifying your vehicle. And the insurer had modified his vehicle. And the insurer, and of course, said, well, it didn't matter. It'd be up the breach of the harmless effects to rely on it, expressed under that effect. But some years later, in Missouri, it was, nah, that's nonsense. Of course, you can rely on the contract. And finally, is there a tort of bad faith? Can you rely on tort as an alternative and means of getting damages from insurers? A Singapore case with standstill in 2012, this is a case in which the insurers cancelled the policy on rumours policyholder was insolvent. Tort bad faith was argued and the judge said, don't be silly. And very recently, in this jurisdiction, in New York jurisdiction, the Airman case, which my research assistants found for me, thank you very much. In this case, the Judge Bloom in New York Court just said exactly the same thing. You cannot superimpose tort onto a contractual relationship. So, how do I summarise that? I think I summarise that by referring to my first slide, is that most good faith a myth? And I think you've had my answer.
So that's classic Rob Merkin, right? In the course of his presentation, he pointed out, oh, by the way, Mackenzie Chalmers got 2,000 of the 3,000 cases wrong, right? Rob has read every case. In fact, I wrote a review of his magisterial history of marine insurance. I said exactly that. He seems to have read every single case. And it's not just a combination of knowing everything, it's that really sort of penetrating, clear analysis. So that's sucking up to Rob. Now my task is to ask whether there are any questions of Rob. David.
So thanks so much for coming to New Orleans and presenting this for us. So my question has to do with this pre-contractual time frame. If there is an effort to engage in an act of fraud, at the time that the pre-contractual duty existed, does that end at the time that the contract is effected? Or does that pre-contractual duty hang over the heads of the contractors past the point of the pre-contractual time frame?
Yeah, if you've been guilty of fraud in the presentation of the risk, or you've been guilty of some dubious behaviour that you haven't disclosed to the insurers, then yes, they discover it. They can avoid the passing. But there are a couple of limitations on that, because in the UK now you can't simply avoid, you have to prove you wouldn't have insured in any circumstances. If you can prove fraud, you can avoid anyway. Up until we changed the law, fraud didn't matter. The only difference that fraud made is that the insurers get to keep premiums they can prove for it. But they never did what they simply did. Why go through the agony of proving fraud if you just prove that it was wrong? So you just pay the premium back and say, go away. That's what happened in practice. But if there's been fraud, then it's an automatic right to avoid in English.
Thank you.
There was number one over here.
I've just heard anecdotally that it comes up in the settlement of claims where the insured doesn't have very good proof of his loss, but the insurer says, we'll give you the benefit of the doubt.
Mm. Yeah, the problem with academics in particular is that you only ever see the cases that don't say 99% of them do. So of course insurers want to keep their customers, they don't want to ban this. And so they'll pay, even though their customers have no need to or whatever. So yeah, those cases. To give you another anecdote, my youngest daughter from New Zealand, she was seconded to an insurance company in the earthquakes, dealing with the earthquake case. And this guy went on television and said, I took out a policy after the earthquakes and claimed on it. But because he said my insurance agreed to pay. And because he'd been on TV, what are the insurers supposed to do in those circumstances? So they swallowed the card, bit everything they could find, and paid. So you do get situations where sometimes the insurers are embarrassed into paying, so they think it's the right thing to do. Insurers are not evil people, intrinsically. They don't want to pay, they want to deal with their customers if they've got decent paying. I've always said about insurance law, and Martin, I may get back on this, may not, hopefully you can. But the reason that insurers give them a paying is not the reason insurers have them a paying. But very often it's suspect something that they can't prove, so they plead what they can. And one of the beauties of the 2015 UK legislation is that if you want to plead something, you've got to prove it. You want to not pay, you've got to have a reason for not paying. But the punishment has to fit the crime. But I think you're right, so that insurers will sometimes say when they think it's the right thing to do. Yeah, point.
Any others?
Oh,
Now you're in trouble now, right?
already.
No, mine is not a question, but just to add what you said, Martin, about Rob's detailed analysis of every single case. I remember that years ago, I believe that it was Lord Justice Riggs when he was a Court of Appeal judge. I think he said that Rob also explains to the judges their reasons in their judgments.
Yeah, I can embarrass myself easily, is good. Which is probably one of the best judges of all time. It's quite
All right, well, now it's time for us to go and have some supper and a glass of wine. And before we do that, please join with me in thanking Rob for